Okay, well, in the interest of everyone's time, let's go ahead and get started. Thank you, Ms. Heidi. Want to welcome you to today's session, and I think it's going to be one that's really, really informative. Graham has been with us for a long time, and the extent of information and knowledge that he has is really stunning. And so I think that you're going to wind up getting a lot of out of it. And so, Ms. Heidi, if you can give us the next slide, please. So these series of classes that we put on, and we put on somewhere between 14 and 16 classes a year on various topics having to do with international
Oh,
business, exporting, and supply
that's
chain
okay. That's right.
management.
I'm just listening.
Okay, if you guys can mute
Yeah.
your
Okay. Yeah.
mics,
Days, both rooms are open, Wednesday and Thursday.
if if you guys would mute your
Yeah. I mean, the computer
mics.
room's fine too. So yeah.
So I highlighted the dates that are open.
Peter, could you mute your
Oh,
mic?
oh, I thought I muted.
No worries, no worries. As I was saying, we try to put on somewhere between 14 and 16 classes a year, and all the classes are
Moody, Moody.
looks like I went muted all of a sudden here.
Yeah, I was trying to mute
Yeah,
someone else and accidentally hit your name.
no
I'm
worries,
so
no worries.
sorry.
The Arkansas Manufacturing Solutions, as it says, only works with manufacturers, and they provide a wide field of services for any Arkansas company that is into manufacturing. Their mission is to maximize the enterprise value for manufacturers through innovation, operational excellence, sustainability, and leadership development. Next. And for those of you who perhaps are not as familiar with the District Export Council, there are 60 DECs, as we call them, throughout the United States, and we're all appointed by the U.S. Secretary of Commerce to be members of the District Export Council, and we're charged with encouraging and supporting the exporting of goods and services that will strengthen individual companies, stimulate U.S. economic growth, and of course, create jobs. I'm Rudy Ortiz. I happen to be a business consultant with Strategic Business Services here in Little Rock, Arkansas. And I'm also the chair of the DEC's Education Committee. And so with the help of Ms. Heidi, we put on these 14 to 16 classes on various topics pertaining to international business, focused on exporting and also on supply chain management, which of course is very closely tied to exporting and importing. So as it turns out, today we are covering the very last of the 6-part classes that we call Grow Your Exports, and it's going to be about trade regulations and legal issues. And we have a marvelous speaker today. If Ms. Heidi, if you can get us to Graham. So Graham is a partner with Catlett Law. He's been with the District Export Council for many years. Is absolute a stalwart member of the DEC, and he was also the chair of the District Export Council at least a couple of times that I'm aware of. Mr. Catlett, he assists very selective private companies in developing commercial, legal, and political strategies for their growth into the domestic and international markets. He has been a goods and services exporter for over 30 years now, has owned several businesses that do business in the United States and Europe and other parts of the world. As a matter of fact, he was the first person to start a company in Russia, bringing in all sorts of foods. He started off by bringing in frozen foods, and then later on dry foods, and then all sorts of foods that were targeted at the retail market, at restaurants, and hotels. And so, doing business in Russia is not for the faint of heart. And he was very successful with that and continues at this moment to be involved with international business, providing all sorts of services, consulting services, brokerage services, both in Russia, the UAE, and India, and probably other places as well. So not only is he a top-rated international attorney, but he has real world experience in actually doing this stuff. So he's somebody that would be a very great resource to anybody who wants to do international business. And so, Graham, with that, I will let you take it away.
Thank you, Rudy. And it's a pleasure to be here with everybody today. I want to make this very informal because there are so few of us. Please interrupt me at any time and we can talk about the issues that are most important to you, because I think that's what you'll get most of is those issues that could be helpful to you in your operations and in your daily lives. I will also say that as a member of DEC, it is my privilege to brainstorm with any of you at any time. If you have questions, you can call me or email me, and email is probably the easiest way to reach me at no cost, of course. And maybe we can work out some solutions for problems that you face on a day-to-day basis. What I plan to talk about today, but again, I'm happy to diverge into anything that's more important to you. But the topics that I plan to talk about are how to best manage a legal risk for an Arkansas exporter first, then talk about the different business models that you might use to sell your goods abroad. Third is to talk about export sales contracts. And by the way, next Wednesday at this same time, there'll be another 1-hour seminar in which I'm going to talk about export sales contracts in much more depth, and I welcome you to that. Then distribution contracts, U.S. export regulations, foreign regulations and trade barriers, and free trade agreements. And what I'll go through principally today will be a checklist of legal issues for you to become aware of. We won't be able to answer all the issues that are raised here today, but I think our objective is to alert you to the issues so that if something arises, then you'll know that it really is a legal issue or it's an issue that requires further thought. The first topic is how to manage a legal risk for an Arkansas exporter. And I have come up with this list, which I think is the baseline for exporters. Now, as I read through the list and discuss the points, it's clear that you won't be able to satisfy all of these. But if you can satisfy all of these, it's probably the best way to manage risk. If you cannot satisfy one of these, then you should be aware that you are deviating from a managed risk issue into one that becomes a little more risky. And so you should give it additional thought and consideration. So going through these, my first point is to sell direct and never leave home. And I say that because if you can sell from your office in the United States, then it is a lot less risky than if you go abroad and make sales. If you go abroad, then there are issues of whether you need to be licensed or registered in that other jurisdiction, whether there are income tax consequences of you being in that other jurisdiction, and the list goes on and on. But the first point is if you can, the simplest thing is to sell direct and never leave home. The second one, which sounds a little silly, is to sell only to good folks from a good place. But as you might realize, and particularly with those of you who are experienced, that is one of the most critical ones, because you don't want to be in a position of having to enforce a contract. And in some places, contracts are not enforceable. So the best thing is to find good folks in a good place. Now, what's a good place? Well, there is a chart of the ranking of countries that honor the rule of law and that have low corruption. And I would suggest that you look at that chart and see how the country that you're dealing with ranks on that chart. And let me tell you, the United States is not in the top 10 either. So keep that in mind, that selling to reputable companies in places that honor the rule of law is an important characteristic. Third is payment issues. And of course, I think everybody knows that if you can get all your money in full up front, then that's better. Or a little less ideal is to have a confirmed letter of credit or some other insured receivable. But that's not always possible either. Particularly as business develops, your customer may require you to have some kind of credit arrangement with them, and that becomes a little more problematic. The next characteristic is the delivery terms. Ex Works is the best for you because it shifts the risk of loss at the time of possession and transfer at your dock. And so you assume the least amount of legal risk if you sell on an Ex Works basis. We'll talk about different Incoterms and how they will increase your risk, but that's the one that's best for the exporter. I then add no warranty, no bribes, provide that Arkansas law applies, and that if there is a dispute, that it's arbitrated in Arkansas. So that, to me, is the baseline of how to manage the legal risk, ideally, for an Arkansas exporter. And if you can do all that, then you can relax, you've got it made, and there's no problems, or fewer problems. Let's now talk about business models, because although you may start by selling direct from the United States, there are other business models that you may want or need to employ to maximize your sales. One way is to have a sales agent who represents you in a foreign country or in a region, and that person works either with you exclusively or with someone else. A second type is to have a distributor, and distributors have different advantages and disadvantages, and we'll talk about those a little bit later. Then as we increase our entry into foreign areas, a representative office is another business model. Generally, this means that your company has an office, but the representative office is for the purpose of generating sales and marketing rather than actually holding an inventory or doing any construction or manufacturing work. Another type is a wholly owned subsidiary, which increases your activities a little more with income taxation and compliance with the employment rules of that country. And then, of course, there's a joint venture or partnership with a foreign company that gets you even more involved in that country and requires negotiations and doing business with a partner, which has its own advantages and disadvantages. But those are the various business models that I suggest you consider as you're developing your sales abroad. Now let's turn our attention to another topic, which is sales contracts. And again, as I mentioned, I'm going to cover this in much more detail next week. But to give you the highlights, I consider there to be essential terms in a sales contract and terms that are helpful, but perhaps not essential. Now, as a legal matter, you don't have to have very much to have a sales contract because the law will answer a lot of the elements of a contract, even if you don't agree with your with the other party. But generally, you don't want the law to imply those terms. It's a lot better if you decide for yourself what are the better terms for you and your party in your transaction. And so the question comes up, do you really need a sales contract at all? And I, again, kind of tongue in cheek, answer the question by saying, no, you don't need one unless there's a dispute. If there's no dispute, then you don't need a contract. But who's going to know up front whether there's going to be a dispute or not? And so I recommend a contract in all situations. Now, the objectives of a contract are something that you need to think about, and how lengthy the contract should be. Well, let me suggest to you that the objective of a sales contract is to avoid a dispute. And I say avoid a dispute because nobody wants to get into a lawsuit involving an international contract. It's much too expensive. Nobody wants to ruin a relationship with a customer if they can, because that can be fatal to the relationship. And so another reason, and I think the primary one for a sales contract, is to specify as many terms as you think you can think of, so that if a dispute might arise, both parties can refer to that contract and have the contract answer the question without there actually being a dispute in fact. So, what are those terms that you want to put in a contract? Well, again, the essential terms are the parties. The first one is the parties. And I don't mean that just to have the name of the parties correct, but you need to understand the parties. You know, are they experienced? Does your buyer have a financial ability to perform the contract? Does your buyer have an experience of failing to perform contracts? And of course, as we know now, sometimes you have to check the buyer through the sanctions list to make sure that they're not on a sanction. But in any event, knowing your buyer is an important, essential part of a contract. The next term is a price term, which is what we all think is probably the most important. But it's not just a static price that should be in the contract. You have to think about currency and what happens if that currency fluctuates during the term of the contract. Who's going to bear the risk of currency fluctuation? In a contract involving commodities, there could be changes in weight. And in many contracts, there could be quantity changes. Often when some of the items do not arrive when delivered or are not in good working order. So how do you handle those weight and quantity changes? And I recommend that you provide for it in the contract. Finally, as far as price, consider the effect of taxes, insurance, freight, unloading, and inspection, and who bears those costs. because all of those affect the price and they can be the source of disputes if you're not careful. Next essential term is payment. When are you going to get paid? Of course, we want to be paid in advance, but that's not always possible. But when is the timing for the payments going to be? Is it part now and part never? Or if it's going to be part later, then when will that later be? And how do we know that we're going to get paid later on? An issue that comes up sometimes when you have inventory and receivable financing is that your bank may not give you credit for your inventory after it leaves the United States and while it's in transit. And so it's important to match the payment terms to your financing so that if you need a bigger bump or perhaps all of your sales price at the time your products leave the United States, make sure that that you're not that you are in compliance with your financing terms. Then methods of payment. Of course, prepayment is ideal. Some people accept credit cards for prepayment, but I caution you to check the credit card agreement that you have with your bank, because some provide that even months after the transaction, the bank can charge your account in the case that the buyer did not pay the credit card or was in some way it was a fraudulent transaction. If your credit card company assumes that risk so that when the money hits your credit card account, then that's not an issue, but it's not always the case. Letter of credit is another method of payment, open account, government insurance, XM, SBA, and private insurance. And all those methods of payment are another topic for seminar, and you may have already covered those during this series of lectures. The next series of essential terms that I'd say is a detailed goods description. And it's not just the description, but also the quality and the quantity and a consideration of whether they're going to be inspected at some point before they leave the United States or before they leave the dock, your dock, and to make sure that those goods are as provided for in the contract. Delivery date is another essential term, and what happens if it's early or late? Who pays the demurrage or the additional storage, or is there a penalty in case the goods arrive late? Next, we get to the term of Incoterms, and I hope you are all familiar with Incoterms. Incoterms is a set of terms. It's not a contract. It does not form a contract, but it is a set of rules which can be incorporated into your contract, which govern the delivery of your products. The most critical things that they do is that they resolve the transfer of possession, when possession of the goods are transferred, when title is transferred, and the transfer of risk of loss. Now, for those of you who are vaguely familiar with Incoterms, you know that they are abbreviations. But let me say that the use of those abbreviations is much more than the shorthand version that you may think constitutes Incoterms, because by using Incoterms, you are actually incorporating into your contract about 20 different contractual terms for the buyer and the seller, some of which you may not have intended to incorporate. And the solution for that is, as I say here, buy the International Chamber of Commerce book on Incoterms. And let me hold it up for you, because this book will specify all of the Incoterms, and it has the rules that apply when you use those Incoterms in your contract. And many people think that Incoterms are just a delivery term or even a payment term, as to who pays duties and who pays insurance, but it's much more than that. And so I recommend that you buy the book and study the full effect of the Incoterms on your contract. But for sure, use the Incoterms, because they are a shorthand way of incorporating generally accepted international transaction terms into your contract without you having to spell all of them out. Another part of a contract, and probably the reason, as I said, that we want contracts, is to avoid disputes. But when there is a dispute, we need to figure out how we're going to resolve that dispute. And there are three different things that you should consider in your sales contract about how to resolve a dispute. The first is which law governs. Now, if we're dealing with a company in the United States, it's not really a problem, because each state has adopted a form of the Uniform Commercial Code, and generally they're about the same. So the law is pretty much the same. But if you are exporting, the law is not the Arkansas Commercial Code, but it can often be something called the United Nations Convention on the Sale of Goods. And who knows what that is? Although it is similar to the United States Uniform Commercial Code, it is different in some respects. But sometimes neither the United States Uniform Commercial Code nor the United Nations Convention on Sale of Goods applies, and you could be subject to the law of a country in which you have no idea what the law is, and it could impose some obligations on you that you do not want imposed on you. So, back to my first slide about managing risk. Whenever you can, specify that the Arkansas Uniform Commercial Code will be the law that governs your contract. It's not always possible, but if it is, we all know what that says, and we can look it up pretty easily. The next issue is, where will a dispute be resolved? Well, as you might think, we'd prefer it to be in Arkansas, because it's cheaper for us to handle the issues and attend the court or the arbitration hearings, and to handle our witnesses if they're right here in Arkansas. But the customer doesn't always want that. And often the customer will say, well, I want it to be in my country. And if that country has a reputable rule of law, then perhaps that's okay, but it's going to cost you a whole lot more. And sometimes a customer will say, well, let's pick a neutral country like Switzerland or Sweden. And that also is okay. It's just going to cost you a lot more than if it were in Arkansas. And of course, even handling the dispute in New York will cost a lot more than it would in Arkansas. So at least keep that issue in mind when you're drafting a contract, because it's easy to just agree with whatever your buyer wants. But in case of a dispute, it can become a substantial additional cost to you. Third element about dispute resolution is whether you use arbitration or litigation. And there's probably no easy answer here, and in different contracts and different parties and excuse me, for different reasons. One could be the other, one could be a difference for the other, a reason for one or the other. But let me give you an example that came up in my firm this week. Is we've been working on a case just here in Arkansas that involves over $1 million contract case, and we're all ready for trial. When we contacted the judge said, fine, we'll set a 2-week trial, but the first availability I have is a year. And so the parties will just have to sit on their hands for a year while we wait for that opening to occur with the judge. Generally, arbitration can be handled quicker, but it's something for you to consider and something for you to deal with your attorney. As far as helpful terms, there are different categories of things that you may want to cover in your sales contract. The first is, what about warranty? Now, under the Uniform Commercial Code in Arkansas, there are 2 types of warranties that are implied into a contract, whether you include them in your contract or not. And you may not know that they're there. So you need to be aware and think through what warranties you want to provide your buyer. Now, under the Uniform Commercial Code, you can disclaim those warranties, but it has to be done in a clear and conspicuous manner. And so that's part of the warranty issue, but a bigger part is what happens if it breaks, or if the product doesn't arrive in good condition, or if the buyer wants service. How are you going to deal with those issues? So the whole issue of warranties or disclaimers and service is something that requires some thought. Indemnification is a legal word which means that if, for instance, your distributor does something to affect your product and it hurts someone else, or your customer is hurt, or your customer's customer is hurt, and they sue you as the manufacturer, then do you have to pay to defend yourself, and what rules apply to protect you? And what we'd want to do is to put in your contract that if your distributor or your customer use the products in a way that were different from your instructions, then they would indemnify you against their own wrongful actions. Protection of intellectual property is a big problem. There are some countries you go to where you might as well forget trying to protect your intellectual property, and the best way to protect it is just don't disclose it to anybody. Some companies even export only their models from 2 or 3 years ago, and not their most up-to-date models for that reason, because they're worried about intellectual property being stolen. But sometimes you have no choice. You want to use your trade name abroad, and you want to share your particular product in a way that puts it at risk. And so you have to think about how best to protect your intellectual property. Confidentiality. Do you want the terms of your sales contract disclosed by your customer to perhaps other customers? Probably not. Do you want your customer to go into business and compete with you? Probably not. Do you want your customer to solicit your sales agent or people from your office so that they don't have to teach them and learn everything yourself? Probably not. As far as diversion, companies have different policies about this. Sometimes they don't care where the products end up, but other times they want to sell specifically into a particular market, and they don't want that distributor or customer diverting the products into a different market because they may have different marketing strategies in different countries. For instance, your distributor in France may be prohibited from selling your products into Germany because you may want to use a different German distributor and you may want to have a different philosophy or strategy for selling into Germany. Distribution agreements are something you're going to run into quite a bit because it's a very common way of selling your products abroad. And when you do, I've made a list here of some of the common distributor duties and then some of the common producer duties. So in developing your distribution agreement, you should consider whether you want the distributor to assume these responsibilities, such as having a minimum inventory, spending a certain amount on marketing expenditures, having a particular marketing manager to sell your products so that they don't just get all mixed in with all the other products that the distributor is selling and maybe not giving enough attention to yours. Perhaps the distributor should be required to have promotions at certain times of the year, have certain sales goals in order to maintain his right to distribute your properties. Sometimes we would prohibit a distributor from having competing products so that they can focus only on your products in a particular line. Again, back to the diversion issue, and then the issue of whether it's a limited territory or an unlimited territory, and whether you're going to have exclusive rights within an area or not. On the other hand, you should be prepared that the distributor may want to ask these things from you. They may want to ask terms, credit terms. They may want to ask that you have translated your marketing materials into their language. They may want to ask that you have labeling in their language, and sometimes the law of that country may require it. Some countries prefer particular tastes or have other customer profiles that may help you sell your products in that country, and the distributor may want to require you to adjust your product to meet those taste or other customer profiles. Trademark registration is one thing we've talked about. I had some experience with that in one country. One of the biggest beer company started selling its products there after it had registered its trademark, but then later lost trademark lawsuit and had to stop selling in that country until it bought the company that actually owned the trademark. Next is the contribution to marketing expenses. Some distributors want the producer to contribute to their own marketing expenses. Of course, advice, and the distributor will want an exclusive territory. Other contracts that you should be aware of, and again, I'm primarily providing you a checklist of things to look at without digging into any of these in detail, although we could spend a lot of time on each one of them. But financing and letters of credit are complicated issues, and don't think that using a form letter of credit is an easy solution to a letter of credit, but you should understand what it means. Also, in your transportation contracts, note that there are exclusions from the carrier's responsibilities, and there are limitations on the insurance that the carrier will provide you. There are contracts to help you with. I mentioned earlier the International Chamber of Commerce, which you can Google, and it has not only the book on Incoterms, but there are several contract forms that you can buy from it that are well designed for export transactions, and they are used around the world so that their terms are understandable and recognizable. Particularly, direct your attention to the export sales agreement and the distributor agreement. Now, those are unfortunately not the only legal issues that you can face as an exporter. The ones that can bite you are some that that you may or may not have heard of. The first is what I'd call the economic sanctions, which is regulated by the Treasury Department Office of Financial Asset Control. And this is where the boycotts, the anti-dumping, and sanctions are implied or imposed. And you may have most commonly come in touch with this if you've ever tried to get to Cuba, because OFAC handles those Cuban rules, but there are economic sanctions that are applied to countries, and we have to be aware of those whenever we're exporting, particularly to certain countries, and I'm sure you can identify those that we have to be particularly careful about. In addition, there are export controls. There are controls on arms and military apparatus, which are under the ITAR regulations. And then there are general export administration regulations, the EAR rules, which govern the export of others. Now, in many transactions, there are no requirements or prohibitions, but in some you have to get a license to export the product, and in others you actually have to, they may be prohibited. But export controls is a second area other than sanctions that the United States imposes legal rules on the export of products. In addition to the export of products, we also have rules about corrupt practices. And the one that we should be the most familiar with is the United States Foreign Corrupt Practices Act. That act, which is a United States law, makes it a felony for an American citizen to bribe a public official in another country in connection with a contract. Now you'd say, well, that's a little strange. We might understand that it violates the law of that country, but why should it violate the law of the United States? Well, let me assure you, it does. And so on a regular basis, companies are charged with criminal violation of bribing foreign government officials in order to make a sale. Now, it doesn't apply to everything. You can bribe a foreign government official for doing some very minor things, particularly those things that would be done in any event, and give them a nominal gift, and that there are specific exclusions. And it does not apply necessarily to the bribe of a private company abroad. Now, the local law may prohibit it, but the U.S. law may not prohibit you from bribing a private official as part of buying your product. And sometimes, as we know, that is an issue. The difficulty comes in when we question whether the private company is actually owned directly or indirectly by government. And if so, then that Foreign Corrupt Practices Act would kick in and would subject the American to liability. There's also a United Nations Convention Against Corruption, and some other Western European countries have laws which prohibit corrupt practices. There are other laws that impact exporting, and I've listed a few employment laws, environmental laws, trade laws, tax laws, and antitrust laws. And of course, we can't get into all of those today, but just be aware that there are more.
So, Graham, a question
Yeah,
for you.
sure.
I think that for clarification, when we're talking about, bribing some sort of a minor official to do something for you, you're talking about like expediting the process.
Expediting, that's a good way to put it. You could do that to expedite the process if it's something that's going to be done anyway, then yes.
Thank you.
Okay. There are treaties which can also affect our ability to sell abroad, some in a good way and some in a bad way. I want to talk a little bit more later about foreign trade agreements, but treaties are a particular body of law which could be important to be aware of. Then when you satisfy all of the U.S. rules, there are also foreign regulations you should be aware of. And let me run through these quickly. Customs clearance, trademark protection, import licenses, labeling, consumer product and health and safety. And some European countries have stricter rules than the United States does. Product and quality standards, product warranty, and specification. Now you say, well, if I'm selling X Works, do I have to worry about any of these? Technically, no, because you're selling X Works. But your customer is going to have to be aware of all of these things. And for instance, if there is a label on your product or a quality standard or a packaging or marketing that is not sufficient under the local law in the export buyer's country, then you may need to resolve that with your customer before it leaves your dock. It's certainly a lot easier to change the labeling when it's in your factory than if it doesn't get changed until it arrives abroad. As far as free trade agreements, these are treaties which exist between countries to reduce or eliminate customs duties, agree on product standards, they reduce documentation, they allow selling to the government, and they allow service companies to supply product and provide fair treatment for investors. These are very important. And I would suggest that as you're looking for export markets, you try to find a country that the United States has a free trade agreement with. We now have free trade agreements with about 20, which cover 47% of the goods exported from the United States. A significant one that we do not have is Brazil, and that makes it very difficult in some respects to export to Brazil. A few years ago, there was talk of a Trans-Pacific Partnership Agreement, but that fell through and perhaps is being rejuvenated, although there is a big political issue about free trade today. There is controversy about whether free trade costs U.S. workers jobs and whether it makes it too easy for products to come into the United States to compete with products manufactured in the United States. So watch for that issue about whether free trade is politically acceptable today. It continues to be a hot issue. Well, that is a very quick checklist summary of legal issues to keep you from sleeping at night. And I'm happy to answer easy questions that you may have today, or you're welcome to email or call me at any time later, and I'm happy to work through some of these with you.
Yeah. Graham, thank you so much. As always, tremendous information, and I think you folks will see why I put such high regard by what Graham says, because he's just an expert in so many different areas, and he'll really keep you out of trouble. Now, we do have one question that I am seeing here from Mr. Bankston, and I'm not exactly sure that he has it right, but we'll read it just the same. It says, "I've heard that X Works is risky because you have no control over where the goods are actually going. A sales agreement / include terms, including shipping and insurance guarantees that the goods are leaving the country and going to the actual customer." Well, I guess if you're selling missiles, you probably wouldn't use X Works, but if you're selling sweaters, where it's actually going, who cares, right? But do you want to respond to that, Graham?
Yeah, and I think several of the issues that I raised are involved with that question. One thing is selling to good people. I remember when I was a distributor, one of the companies that I wanted to sell for conducted a background search on me to make sure that I would do what I said I was going to do, and I wouldn't divert. And so they were very serious about that. Secondly, it is common in some countries to go through that diversion. Let me give you an example. We have cut off a lot of sales to Russia right now, but Russia is able to get a lot of those products in any event by having them shipped to Belarus or to Kazakhstan and then reshipping them into Russia. So that is a transfer that the manufacturer did not agree to and did not approve of, but it's still happening. And so dealing with good people, having a good contract, and then policing where those products actually end up is all part of what you do. But as the questioner asked, you can't totally rely on the contract itself.
Yeah, for sure. And I had one experience where I was working with a client, and my client was producing fertilizer manufacturing equipment, and all the equipment went on a skid that one could use to make fertilizer. Well, fertilizer, of course, you can use it for putting on agricultural products, but unfortunately, it can have a dual use. You can also make some serious explosives out of it as well. And my client had received a very substantial contract for one of his fertilizer making plants on a skid, and the location changed right before the product was ready to be shipped. The company that was buying this product all of a sudden wanted to switch it to a restricted country, and of course that sent up all sorts of flags, right? Because that is a favorite ploy of bad actors, is that they'll tell you that you're going to ship to London, and then at the last minute they want you to send it to Iran. So that's something that you definitely have to be very, very careful. These last minute changes of where it's going to, be highly, highly suspicious of what's going on there.
Graham, this is Eddie. A couple of questions I have. One, to reiterate that point, I remember many years ago when I was working for a U.S. exporter, the product was sent to Egypt, but it ended in Libya. The moment we discovered it, we immediately reported it through our attorney to the State Department and the appropriate authorities. But then what we decided to do, in addition to a sales contract, every transaction has to be backed up by a credit application. And we put a section on that credit application requiring, under the terms and conditions, that the customer signs. First, answer the question: are you the ultimate user? Are you the middleman? Where it's going? Is there going to be rerouting, transshipment, and who is the ultimate end user in country? And they will be signing that this is the end user, and that person is neither under sanction, neither the country nor the person, and so forth. Do you think a clause like this will protect the company. That's the first thing. The thing you mentioned about credit cards, I love that, because we had a case after a year, a customer decided to reverse the charge. But what we always did in the credit department, for every transaction, not blanketly, every transaction on credit card, we didn't agree to it until they sent us the copy of the credit card front and back, and they sign a form that says that this company, this person is in part authorized to sign in this transaction. Do you think these two documents will be able to have good protection for any company?
Well, Eddie, as far as the second one, the credit card, I think you're doing everything that you can do, but still the better thing is to get the credit card company to waive that provision that they can deduct from your account after the transaction. If that provision's still in there, then they would still have the right, even though you've had the original credit card given to you, because they can be fakes too. But I think you're going a long way to protecting yourself as far as handling it. As far as the diversion, yes, that the steps that you suggested are certainly helpful. But again, if somebody is going to commit fraud, then they're going to sign anything, whether it's true or not. And it's very difficult, to actually manage the transfer and the delivery of the product where you want it to be. And as Peter suggested, you send it Ex Works and you don't know what's going to happen after that. But even after the product is delivered to the proper place, it could be unloaded and reloaded and reshipped. And so those can only be solved by dealing with good people.
I think at the end of the day, we're trying to protect ourselves. And I will tell you, the federal government and the agencies that are over these issues have no sense of humor. They really don't. And so anything and everything that you can do to have language that, I'm not sure that absolve you is the correct word, but that will, show the government that you really did do everything you could to handle this in a way that is professional and would not endanger the security of the company of the country. I'm sorry. So it's really very, very important that you take these matters very seriously.
Exactly right, Rudy. Thank you.
And Graham, I think this is for the first time I saw this. I want to really add a point on you when you mentioned about Incoterms. I think it's brilliant the way you put delivery method, because I worked in credit field 40 plus years, and many times people mistaken credit terms with Incoterms or credit terms with sales terms. So when I saw that, I thought, interesting, light bulb. Sales terms should include the credit and payment terms plus the delivery method. So in essence, when I think of sales term now, credit terms or payment terms, whether it's net 30, LCs, whatever, plus the delivery method, which is the Incoterm. So I'm going to be using this formula. If you talk about a sales term, now really talk about the payment mechanism plus the delivery method. So I thought this is brilliant. So you brought a new perspective into what a sales term should be. So
Good.
Thank you very much.
Glad it was useful.
At this moment, I don't see any other questions. Anybody have? Feel free to unmute yourselves and to make whatever comments or questions you might have.
And Graham, can you share with us your contact information as to the phone number? I see your email only.
Yeah, we'll do that at the very, very end. We'll have everyone's contact information, obviously, especially Graham's, and you'll have access to that at the end of the session.
And Eddie, let me suggest it's easier to reach me by email because I'm often in meetings and not able to answer the phone. But if you can, you're welcome to call. But email, I'll always respond.
Oh, perfect. Yeah, and he will respond quickly, I will tell you.
Good, thank you.
There is one question in the chat.
Okay. Oh, okay, yeah. This is from Tommy. He said, "Isn't a lot of the terms in the commercial invoice?"
Well, a commercial invoice can be your sales contract, and that is the place where you could have a lot of your terms. Or similarly, if you have a proposal for a purchase or an acknowledgement of a purchase, then to have your terms in that document. So just so long as there is a writing which specifies these terms that we talked about, then I think that's good. Next week I'll talk about whether you can do it on the web or in an email, and the answer is not as clear, but it's possible for you to do that also.
Yeah, and that's a good segue to something I was going to say, and that is, as Graham stated, we're going to be having a class that covers contracts much more specifically. Obviously, he covered a lot of information today and was not able to cover it in as much detail as he will be able to do next week. And so we'll be having this sales contract class next Wednesday, a week from today, March the 13th, same time, same station. And so if you guys want to learn more about contracts, and obviously, they say that until you get paid, it's just a gift, right? And so obviously the contract is a critical instrument to get correct. So hopefully you guys will see fit to attend that class to make sure that that you protect yourselves as best as possible.
Yes.
Okay,
Will
Ms.
Heidi,
Heidi.
I'm sorry, Mr. Rudy. Will Heidi be sending that out to be a part of that?
Yes,
Okay,
yes,
Okay.
yes. I will
Thank
send
you.
you the link.
Excellent. I think what we'll do now, since we've already run over, we'll go ahead now to first of all, surveys are the only way that we know whether we're doing a good job or not. Number one, and so if you guys would really take a minute or two to fill out the survey to make any comments that you have about today's session, would really appreciate that. And also, Ms. Heidi, if you will do the prices that we were talking about earlier.
Yes,
Okay.
yeah. So everyone who fills out the survey, you will get a PDF copy of the offshore, which is in exporting book. And then Mr. Richard Duda, our USIAC director, is also providing a copy of the Basic Guide to Exporting, published by the U.S. Commercial Service. So everyone who has come to or watched all of these sessions gets their name in the hat today. So here we go. Let's see if it'll spin good for me today.
Yeah, it's been real slow. We have no idea what's causing that.
Okay, let's see if we can do this. There we go.
Hey, it's
Got
actually
it.
spinning this time.
Oh, goodness. It's
Oh,
gonna
okay.
Hey, it's Joanna. All right. Yay, Joanna. Okay. I wish
yeah.
I could give every single one of you a copy of that book. But you know how the government is. they don't provide much. So
And Miss Heidi, just so that I have it clear in my head, the spin that we did just now is for Richard Duda's not his book, but the commercial service book.
yes,
Okay,
correct.
very good. And everyone's going to receive, unless you've already received it, that document, that paper that gentleman wrote. Is that correct?
That's correct. All they have to do is fill out our survey.
Okay, well, very good. Well, ladies and gentlemen, thank you so much for attending today's webinar. Once again, we hope that you take the time to attend next week's, which I think is just going to be stellar. And we will, at this point, close the webinar, and we will see you next week. Thank you very much.